Just now.
First, 6 an adjournment. The prayer is allowed. The CD received shall be retained. List on. It will be 12th.
It would be 12th, my lord.
12th.
I stand obliged, my lord.
Also, with the consent of other side, I beg to mention item number 6, lordships. I am for the respondents.
6.
6. I am for the respondent number 2. I am led by senior counsel S.K. Singh in this matter,
No,
lordships.
you informed the other side. They submitted that with the learned counsel for the respond number 2, 6 an adjournment with the consent of the other side. Prayer is allowed. List after 2 weeks.
2 weeks.
No.
Also, this
Interim order stands extended till the next date of listing.
So this can be tagged along with criminal petition number 491 of 26, lordships.
Along with list after 2 weeks, along with criminal petition number
91.
491 of 2026.
Much obliged. I beg to mention item number 17, Your Honor. Can we adjourn this matter for the day?
17?
Yes, Your Honor.
17.
17.
Okay. How long? Next week? On for the day?
After 2 weeks, yeah.
Huh?
After 2
2 weeks. The petitioner is inside. Huh? He's in custody. He's in custody. Okay. Let us fix it on 18. Based on 18. 17.
Strip item 29, lordship. CD not. Interim is there, lordship.
Is an interim, my lord. Maybe fixed on, my lord, 29th of
May? Okay. Issue reminder for the case diary, interim extended 29th. Yes.
Please, lordship, I beg to mention item number 21 of today's daily list, lordship.
21?
21, lordship. I further pray for the matter to be listed along with another bail application number 978 of 2026. Lordship may kindly allow to both the matter to be listed and be heard together.
When do you want it? Next week? M21, Lord Council, 6 and adjournment. This is allowed. List, let us fix a date next week. List on 14? 14 is okay? 14. List on 14 along with BA number
978 of 2026.
Wait, please, your lordship. I beg to mention item number 31, lordship. Kindly pass over the matter for the day and fix it on next week, lordship.
30.
31.
31 CD not received.
CD not received, full stop. Issue reminder for the same. Interim is there. Interim order is there. Is there?
Interim there.
We'll check it. Not sure.
Interim perhaps not there.
We'll check it. Rakhi silo. Interim, if any, shall be extended. Check it. Okay. Wait. 22nd. 22/5.
Must oblige, lordship.
The lordship, with the consent of the other side, I beg to mention item number 7 of the daily list, lordship. Lordship, this matter is led by Mr. D. Das. He's been recently engaged, lordship, and he has a personal difficulty,
no problem.
lordship.
7, no?
In this case, lordship.
Respond number 2.
I'm preparing for respondent number 3.
You're for the respondent.
I'm for the petitioner, lordship.
You're for the petitioner. Right, counsel. For the petitioner, 6 an adjournment with the consent of the other side. Full stop. Well, let's fix it today. I have some time constraint. Nothing else is in the first half only. I'll sit only in the first half today. I won't be able to sit in the second half also because I have some official preoccupation. So when should we fix it?
26th of May, if it's
26/5. Any interim order?
deeply obliged.
May it please the lordship. Lordship, I beg to mention item number 48 of the supplementary list, lordship. Lordship, may kindly adjourn the matter for the day and if possible.
48?
48, lordship, bail matter.
When do you want it? Next week?
Next week, lordship. Any date. Preferably 13th or 14th, lordship.
14. Adjourn for the day. 14.
Next.
My pleasure, lordship. Sir, I beg to mention item number 4, lordship. The earlier FSL report was called for. I don't know whether it is received or not.
A report was called for.
Report was called. Earlier 2-3 times.
Oh, FSL.
Yes, yes.
Let us have it next week then. Early next week. Hmm?
No, sir. Can it be fixed on 15? 15
No,
of May?
no problem. So, Any interim orders there? This report is received.
The report, my lord, not received.
Should we issue a reminder?
My lord.
FSL report.
Yes, Lord.
The FSL report is as called for is not received. Issue reminder, full stop.
My lord.
The interim order stands extended till the next date of listing. List on 15.
15. Obliged.
Made please, your lordship. Lordship, item 28 and 52. That I'm paying adjournment and may be taken up on 18th, my lord.
Item?
28 and 52.
28 and 52.
It's
Oops.
hearing on
28,
18th.
28 and 52. The case diary, received, not received. No, the TCR. 28 and 52.
28 is this year.
Okay.
28 and 52.
52. John, and fixed on 15. Interim order.
18, my lord. 18.
18. Interim order is there?
No, madam.
No. Oh, fixed on it.
Prayer, my lord. In the meantime, I may be allowed to go through the record, my lord, because now without your lordship's permission, I cannot.
No.
And
Lordship, I beg to mention item number 30.
30.
Yes, your lordship. CD has not been received. 30.
Issue reminder for the case diary. Interim. Interim is there.
Yes, your lordship.
Interim extended till the next date of listing. List on
From Kokrajhar, my lord, on 26th.
26.
Obliged.
I beg to mention item number 23, Lordship.
22.
23, Lordship.
23.
Report of or efforts are not received.
FSL report is not yet received, my lord, regarding proceeds or not, my lord.
CD is available, but FSL report is not received. Issue reminder for the same.
Interim may be continued.
Interim stands extended till the next date of listing. CD,
21st,
you will retain the CD?
my lord.
Retain the CD.
21st.
You will retain the CD. 21st.
Obliged.
May it please your lordship, I beg to mention item number 25 and 26, prayer for adjournment.
5 and 26.
5 and 26.
Diary is also not received. I will
My lord.
issue reminder for the case diary.
Interim is there.
6th CD received, my lord.
It is received.
21st.
Then let us fix it next week.
Interim is there, lordship.
Okay. The case diary, the 6 and adjournment, however, case diary is received. The same shall be retained. Full stop. Interim bill stands extended till the next date of listing. List on 15. 15.
Obliged.
May I please, Lordship? My lord, item number B and 43, my lord, be taken up together, my lord. Is a interlinked matter.
3 and 43.
My lord, together, my lord, I will do it today.
What is this hearing, my lord?
Item number 1.
Yes.
But there is an IA for impleadment. Actually, we wrongly impleaded say NCB, but it should be Directorate of Revenue Intelligence.
So only for that. It has come up for the okay. Today IA has come up, I think.
Yes.
Hertz, let's see, this was current council, M taken. The IA has been filed for impleading the DRI as the prosecuting agency.
In place of NCB.
In place of NCB, which was wrongly impleaded as a respondent. Full stop. The prayer is allowed. The necessary amendment may be made in the cost type.
Registry is to do. Madam.
Registry will do. Registry shall do the necessary amendment in the cost type. IA stands disposed of. So after that, it will be listed. The
Yes,
bail
kindly fix it, madam, for hearing.
Yes.
Long pending, madam.
Yes. Full stop. Pursuant to order passed in the IA number 442 of 2026. And after necessary amendment regarding the implement of DRIs made by the registry. The matter may be listed for motion hearing. We can fix it next week.
All right.
Next, when do you want it next week? Wednesday?
Yes.
No? That is.
Maybe for the time being, Mr. H.R.A. Chaudhary will appear.
Hmm?
Mr. H.R.A. Chaudhary will appear in this case, for the time being.
Or should we, because if it's investigation stage case, we have to call for the case.
Milord, actually, in this case, petitioner reserved for release on bail, Milord, as per allegation, Milord. Because Milord, government settled the fishery, Milord.
Hmm.
And thereafter, Milord, government issued the notification not to fishing. And thereafter, Milord, no point of time fishing by the petitioner, Milord. The petitioner was the authorized person.
Achha. So, he wants to do something.
Yes, I mean.
Bail hearing BA item number 10.
Geometry.
May please, Your Lordship. LCR was
Charge-sheeted case.
charge-sheeted case. LCR was called for.
Let's see.
Lordship, initially the case was registered under commercial quantity, Lordship. Charge-sheeted under the same sections, Lordship. Lordship, the contraband is suspected to be morphine, Lordship, which is 505 grams. And
Morphine, I don't remember what is the commercial quantity.
It's like, 50, 250, madam.
It is, what is this trial has started?
trial has started, Lordship. Lordship, here, Lordship, two accused persons
Charge also.
were arrested, Lordship, along with this petitioner, one other co-accused from whose possession the said contraband was recovered, Lordship. Lordship will find the seizure list on page 26, Lordship.
Yeah, that's okay. What are the materials now against him?
The case is fixed up for evidence, my lord.
Hmm.
They were traveling together in a train, and from them, my lord,
From both of them?
both of them, my lord, they are claimed, and the suspect, no, it is a morphine, my lord. Morphine recovered from them, my lord. So it is now the trial is proceeding, my lord. It is 16,526 for evidence, my lord. Charges already been framed on 10-3.
Lordship, may come into the seizure list, Lordship. It has been seized only from the possession of the co-accused, who is Avinash Bahadur, Lordship. Seizure list on page 26, Lordship. Not from my seizure list, Lordship, not from my possession, Lordship. The possession
Two
was
passengers were sitting together on so and so.
Yes.
For the place of occurrence of a plastic packet. Like a,
Kindly see what the seizure witnesses has to say, my lord.
Human intention to sell them in Muzaffarnagar, Bihar. Yeah, what do you say? Seizure witness.
Seizure witnesses, they have to say, my lord. Both the persons are together, my lord. They were brought down, my lord. And from them, for prima facie satisfaction, my lord, they are both are together, my lord.
Seems so.
Other things will come up on trial, my lord. I am not saying that they will be
37 will
convicted.
be difficult, I think.
Yes. So deciding at that point will be
No.
difficult.
Lordship, otherwise charges have been framed and nothing has been recovered from the possession of the present petitioner, Lordship.
Actually,
And-
they were traveling together.
Apart from the statement recorded by the police, Lordship, as trial has started, Lordship.
This is anyway.
That he will
DMAD
appear for the trial,
Hmm.
and apart from the confessional statement of the co-accused,
So recovery is, I mean,
although he was together, but not from his possession, Lordship.
anyways, to DMAD, counsel and MP Goswami. Full stop. The petitioner is seeking regular bail in connection with GRPS Gauhati PS case number 139 of 2025, which after completion of investigation resulted in a charge sheet and presently and registered as NDPS case number 26 of 2026 before the learned special judge Kamrup Metro. And white order dated 10/3/2026. Charges have been framed against two accused, including the petitioner under sections 21C29 of the NDPS Act. And the case posted for prosecution evidence. The scanned PCR has been recovered, has been received. Mr. Mehdi, learned counsel submits that the recovery of the contraband in the nature of alleged commercial quantity of morphine was recovered from the other for the co-accused other than this petitioner. I have perused the relevant portions of the case there. The learned additional PP has drawn attention to the statements of seizure witnesses. As per the statement of the seizure witnesses and materials in the materials collected by investigation, though the packet containing the alleged contraband was recovered from the petition from the co-accused, but the materials indicate that they were both of them indicate prima facie that both of them were the materials the investigation states that both the persons were traveling together and with the common intention of selling the contraband in Bihar. The basis of the materials cannot be said at this stage that the test of section 37 is passed in favor of the petitioner, and therefore at this stage the court will be statutorily barred from granting bail. It is hoped that the learned trial court would endeavor to expeditiously carry out the trial. Expeditiously complete the trial. The bail petition stands rejected at this stage.
Deeply obliged.
Obliged, Lordship.
How many witnesses in the charge sheet? How many witnesses? Depends.
No copy, madam.
It's okay, no problem.
Number 11.
Item number 11 and 12, my lord. We have received the case diary, my lord. May I pray that matter will be taken up next? Matter will be taken up next week, my lord. We'll require some time to go through the case diary.
Okay.
Anytime, my lord, to Tuesday or Wednesday.
Mr. R.J. Borwa, learned additional PP submits that the case diary has been received, but prosecution prays for some time to study the case diary. Prayer is allowed. List on. Let's fix it on when Tuesday or Wednesday.
13, my lord. 13.
13? Okay. 13. 13/5. 11 and 12. Same. Anda to sab de hoga. Anda to sab bisi ho gele komai debe.
Wait, please, your lordship. Lordship, will kindly look at my lord, page, my lord, 15, my lord, for a one.
Page?
Page 14, my lord. The forwarding report, my lord. The lordship will see, my lord, the reference, my lord. Bhorlumuk PS case number 16/26, my lord. The case is registered under section 20B2C, my lord. This is a commercial category, my lord.
Commercial category.
Commercial category. Now, your lordship may kindly turn to page 18 for a once, my lord. 18 is the seizure, my lord.
Hmm.
Seizure, my lord, serial number 7, my lord. Description of the seized article, my lord. Different seized packet of ganja suspected covered by paper inside a nylon bag, big size, weigh 8.159 kg. And number 2, my lord, 11.960 kilo. So it comes to, my lord, 20 kilo 10 grams, my lord. That will be evident from the inventory. Your lordship will find, my lord, at page 20, my lord. Page 20, my lord, third column, my lord, the quantity 20.11 kg, my lord. But however, my lord, when this matter
So marginally above the.
yes, no, my lord, I am coming, my lord. Then for drawing of sample, my lord, before the magistrate, my lord, the order starts from page 21, my lord. Order dated 13/2/26, my lord. Now your lordship will kindly turn to, my lord, page 25, my lord. 25, my lord. 16.2.2, my lord. That, my lord, that table, my lord, below that, my lord. Total net weight of the seized ganja is 16.7 grams, my lord. That is 16.007 kg. So it comes under the B, my lord. Intermediate quantity, my lord.
This will be the quantity now.
Yes, my lord, because it was, my lord, weighed before the magistrate, my lord. So accordingly, my lord, on, my lord, 8/4/26, my lord, this court's order, my lord, I was granted bail, my lord. Lordship, have a look at 8/4/2020 bail.
Okay. Interim bill.
Interim bail was given. Now, my lord, the record was called for to, my lord, ascertain, my lord, to confirm whether the weight is, my lord, 16.7 kilo or not, my lord. So the TCR has come, my lord. My learned friend has flag marked that part of the order.
Inventory is okay.
So now, my lord, I am on bail, my lord.
But okay. But she's from Bihar. Huh?
She is from here, my lord.
Conditions have been imposed. Conditions have been imposed. No problem.
I pray before, my lord, that the interim order which was passed earlier by this court may be made absolute, my lord.
Go to color. 8/4/2020.
My submission, my lord, just is from the outside station, my lord. Our presence, my lord, with very difficult, my lord, once he goes, my lord.
Risk is always there. 50,000 at one security.
Yes.
And condition has been given. She shall not leave territorial jurisdiction without the permission of the trial court. That's okay. The conditions are para 2, 3, 4. Para 3. Full stop. The learned counsel, Mr. Datta, submits that though the penal provision pertaining to commercial quantity of ganja has been given, but as per the order, past order dated 13/2/2026 passed by the learned JMFC, who had conducted the sampling and certified the inventory, the total weight has been mentioned as 16.007 kgs of ganja, full stop. And therefore, the contraband would fall in the bracket of intermediate quantity. On the basis of the said premise, the petitioner was granted interim bail earlier on 8/4/2026. Today, the scan TCR has been received, and the prosecution does not dispute that as per the inventory order, the weight of the ganja is 16.007 kg. I perused the said endorsement from the scan TCR as well. Full stop. In the given facts and circumstances, the interim bail granted by 8/4 is hereby made absolute, subject to the same conditions. That is, uthai dibo etu. Bail petition stands disposed.
I am obliged, no? Deeply obliged.
None appears, my lord. TCR received, none appears. Check.
Lordship, this is the third seated matter, your lordship, and today completed 336 days in custody by.
Commercial quantity. Were arrested on
Arrested on 6/6/2025.
what are the materials? Samplex, no? Samplex.
Complex, my lord.
Commercial quantity of
Yes,
complex.
my commercial above 5 kg.
Psychotropic substance.
But they are the local person, your lordship. They have no any sum for absconding.
37 has to be seen.
This
Right?
37 has to be seen, my lord. From the, my lord, reserve part, my lord, directly she was recovered from her, my lord.
She is the only sole accused.
So sold, my lord.
Lordship, on the delay of the trial, your lordship.
Yes, actually, first.
And they are the local, your lordship. Residencies, your lordship.
Heard.
Before Karbi Anglong.
Learned counsel for the petitioner. The petitioner is seeking. The petitioner is seeking regular bail in connection with NDPS case number 87 of 25, pending before special judge Karbi Anglong Diff, within bracket, arising out of Khatkhati PS now 58 of 25. The section 21C 29. Both the petitioners. The gist of the allegation is about recovery of commercial quantity of psychotropic substances in the nature of Sampex plus capsules from the petitioners. No, there are two petitioners. There are two accused persons. One. Yes, yes. Both are here, no? Yes. Vehicle. As per the prosecution case, as per the prosecution case, the alleged contraband was recovered from a vehicle in which both the petitioners were present. Scan TCR is received, peruse the relevant portions there. First up. These are witnesses there.
Yes, my lord.
This is a statement of accused. Both the Caesar witnesses have stated about witnessing the recovery of the contraband from the vehicle bearing registration number BR number AS091. BR number aforesaid vehicle bearing number AS09J. Sorry, AS09J 3090. The informant has also supported the allegations in his statement recorded during investigation. Upon the case is at the stage of trial.
No, yes, my lord. Already evidence started, my lord.
Good stuff. I find from the record that by order dated 15/10/2025, charge has already been framed against the petitioners, and prosecution evidence has also started. in the given facts and circumstances, the rigors of section 37 would apply in the instant case against the accused, and the court will be statutorily barred from granting bail at this stage. Full stop. Therefore, the bail petition is rejected at this stage. It is hoped that the learned trial court shall endeavor to expeditiously complete the trial.
Lordship,
Bail
kindly give me
petition
the liberty for filing again before this court.
Huh?
Kindly give me the liberty, Your Lordship.
Oh.
Not see the file today.
Okay.
Profile this.
No,
Yes, sir.
I should not dispose it of.
Yes, Lordship. Kindly give me the another date, Your Lordship, for read this brief, Your Lordship. I want to study.
So you can file as a second petition, isn't it? Huh? Disposed of. Disposed of.
Obliged.
Item number 15.
May I please, your Lordship, Lordship, regular bail application, Lordship, FIR page, Lordship, 7, Lordship, Annexer 1.
Mhm.
Page 7, Lordship. Lordship, above 2170 days above, Lordship, today.
This diary will be necessary because what is recovered? Heroin or morphine? That's not. Commercial quantity. Okay. This diary is called for has not been received. The issue reminder for the same. Fix on 14. 14. Fifteen.
Item number 16.
Obliged, Lordship.
May it please your Lordship. Lordship, this is a regular bail application, 46 days in jail custody, Lordship. Intermediate quantity, Lordship will find the FIR on page 19, Lordship. It is a 19.76 gram from the seat cover of an motorcycle. That motorcycle belonged to the elder brother of this present petitioner, number 1, Lordship. Now, Lordship, what happened in this case? The forwarding report, Lordship, the police did not sought for custodial interrogation, and so for the Lordship bail objection, that is on page 29. FIR, Lordship, will find on page 19, Lordship.
Yeah. No, 29 grounds of arrest.
Yes, Lordship.
Yes, he did not receive.
But Lordship, up-to-date case diary was called for, Lordship, last time, Lordship.
Mhm.
Now, Lordship, second day they failed to produce the case diary. I am on the length of detention because 37 rigor will not applicable in this case, Lordship. And so far, Lordship, forwarding report, Lordship, kindly go through the forwarding report, Lordship, will find,
Absolutely.
Lordship. They have not sought for police custody, and moreover, Lordship, the ground of objection that, Lordship, on page 29, bottom part, Lordship, can you see, Lordship? In the FIR, Lordship, it is specifically stated the bike belongs to the brother of this petitioner, Lordship. But
That's
how
okay.
this petitioner will know he has taken the bike from his Lordship, brother, Lordship, and that was concealed under the seat cover, Lordship. Had it been in his body, Lordship, that would, Lordship, his
That is why we have to see the case diary.
Lordship, kindly forwarding, Lordship, forwarding
No,
report.
interim is not possible because we have
Lordship,
to.
forwarding report. Lordship, forwarding report, Lordship, bail objection. Kindly see, Lordship, that page 29, bottom part, Lordship.
Yes.
Bottom part, Lordship.
Yes,
Sir, the investigation of this case is initial stage. Now 46 days, Lordship.
Okay.
The arrest of the accused person is a prima facie offender of this case. The co-accused of this case is absconder. Now that cannot be the ground.
The
because
diary has to be seen. How can I
Lordship,
get-
can it be on Monday, Lordship? Can it be on
Drugs
Monday?
cases, man. There's havoc in
Mon-
society due to drugs nowadays. No?
Lordship, on Monday, Lordship, because Lordship, it's from Tarabadi, Borpeta.
Thursday.
13, Lordship, 12. Can it be on 12, Lordship?
13. Issue case diary is not received. Issue reminder for the same 13.
Because they have called for the up-to-date case diary on the last two.
If you have
petitions,
some
Lordship.
personal difficulty, then it's okay. Otherwise, 13. Okay. Because otherwise it may not come. Then time will be wasted.
This is the lordship. My lord, last occasion diary was received and some hearing was done, my lord. In this case, my lord, he was taken into custody on 21/12/2025 and thereafter, my lord, forwarded on 22/12/2025 to the judicial custody, my lord, having an allegation based on an allegation of possessing commercial quantity. Now, my lord, the grounds on which the petitioner is before your lordship, lordship may kindly peruse page number 26, my lord. I have also annexed the certified copy along with the
Arrest memo.
yes, my lord. And in fact, lordship will find, my lord, there is no such column, my lord, as mandated by section 36. That is very apparent, my lord. And in that context, there are so many judgments on the orders of our Honorable Gauhati High Court, my lord.
Arrest memo is?
It's page 26.
Yes, yes, yes. It is.
Page 26, lordship. The certified copy I have annexed while filing the bill.
Arresting officer, arrested person.
Yes, my lord.
And it does not have, what is the infirmity?
That, my lord, either it has to contain the signature of the family members, my lord, of the arrest.
No witnesses.
Yes, my lord. Or there has to be a person, my lord, from the
Police does not know these things. It's in such serious matters in 2025.
He was, my lord, forwarded to judicial custody on 22/12/2025, my lord. And
Diary has come.
in that context, my lord, I have also annexed some of the judgments or orders of our Honorable Gauhati High Court. And in fact, lordship order is also there, where lordship has held that it is a fundamental requirement, my lord, as laid down in, my lord, that is, my lord, page 45, where lordship has held, my lord, that this has to be compulsorily followed, mandatorily followed, my lord. That is, my lord, it starts from 47 paragraph 10, my lord, lordship's observation and finding. My lord. So, lordship, I am also praying on similar ground, my lord. I'm a local person and follow all the conditions, my lord. Big condition may be imposed, my lord, if lordship is pleased to.
You just cross-check. What else can we do?
My lord, I have also meant. Regarding 36 notice, my lord. Yes, my lord. Or if lordship come to my lord, page number 30, my lord. 48 notice, my lord.
Yes, yes.
Notice is person who has been informed by the signature is there.
Yeah, but these are different things actually.
Different thing, my lord.
What is there are two orders, man, of this honor. Order. One is passing of 2026, man. And another is
Read, my lord.
PA now. My lord, these two. Very much says. Get a high court. In it, the bank of this honorable. That in other actually public purpose request. I don't know some of the share and Hero Surfer versus Union. That means all provisions of the image. That observation, it was that when an of which that
Then we'll have to refer it to a larger bench. Refer it to, because let it be
My lord, that issue has already been decided in a subsequent, the same day.
division bench.
No, but the coordinate bench.
No,
And
coordinate
thereafter,
bench.
my lord, relying on that, my lord, the lordship has also, my lord, passed so many.
Yeah, that's true. But since let the dispute be resolved, the whether in terms of in events 37, because Vihan Kumar, it has been clearly stated that if there is non-compliance with 47-48, the bail has to be granted irrespective of statutory restrictions. Now, let a larger bench take a call on this, that if the arrest memo does not have signatures of witnesses, then will the under trial detention become untenable despite the existence of statutory restrictions? Can
Lordship may
have a look at that.
judgments of the.
Because that otherwise confusions will continue actually.
In fact, yesterday also lordship has held, my lord, in one of the cases that it's
Yes,
a mental
that's so.
requirement.
But the thing is that this there are conflicting views, no? Because that will lead to problem. Different views, on the same point can really lead to problem for litigants. Isn't
Lordship,
it?
can we take it up after some time, my lord? Kindly, my lord.
Or let us fix it on Monday or something.
My lord, kindly after some time, my lord. Lordship.
Today we have some constraints actually. We can be on Monday. It can be on Monday. Isn't it?
Let it be, my lord.
Because we have to complete the list today as much as possible.
Not Monday, Monday we have
Tuesday.
some matters outside.
Tuesday? Yeah, no, no problem.
Can it be the 19th, my lord?
No, if it's not late for you, no problem. Can I see that judgment once? No. Because I think it will be better. It's not fair to the litigants and counsels also. We should take on facts, we can take different view. But on principles, we should take similar view. Because that will be precedent. Yes. Can I, Bora, can it be kept here? This order, you will need it. You can make a photocopy. Yes, please provide it, let it remain. Okay, let it remain. And let it be fixed on, you want 19? Should we fix it?
20, my lord.
20?
Yes, my lord.
So, no problem. So,
and copy may be given.
Learned counsel for the petitioner submits that submits drawing attention to the arrest memo under section 36 BNSS that it does not be the signature of any witnesses, and referring to certain decisions rendered by coordinate bench of this court, it is submitted that in such situations on the ground of violation of constitutional provisions in terms of the law laid down in DK Basu, the state of West Bengal, bail has been granted full stop. On the other hand, the Mr. Borua, learned additional PP, has referred to decision of another coordinate bench rendered in PA 887 of 2026, in which a different view is stated to have been taken. And by holding that when the decision in DK Basu Supra was rendered, so don't write like that, that despite any such infirmity in the arrest memo, the same would not prevail over the statutory restrictions like section 37 of the NDPS Act, comma, thereby entitling the petitioner to any bail. In view of the apparent conflict on this point by two coordinate benches, between coordinate benches of this court, the hearing is not concluded today. This is the matter on 20.
20.
Eastern. Don't you think so? You know, that on facts it can be different.
But that issue has been already, my lord, decided by a coordinate bench. Not one, my lord, 2, 3 coordinate benches, and one of the order is that, my lord, it is bail application number 3650 of 2020.
Yeah, that's true.
But
But
whether DK Basu will apply or not, my lord, because of,
coordinate benches, though, it can be, you know, because the coordinate bench is okay.
and
But
detailed hearing was,
what I'm saying is that, again, I'm repeating that on facts, there can be difference. But on principle, if there is, because that's precedent law also. That if I disagree with a coordinate bench, I have to either follow that, or if I disagree with a coordinate bench, I have to refer to a larger bench.
in fact, my lord, in this application also I have annexed one of the judgment, my lord, which is at page 38, which also holds the same, my lord, view of the coordinate benches.
So let it be, I think it will be better it is resolved.
25 will argument.
Okay. It will be better if it is resolved. But let's see, on 28, you can brief. Because once it is resolved, it will be settled. Then we can apply the law uniformly. That is the main philosophy behind precedent law, right? So that law is certain. Law should not be uncertain for litigants, lawyers, for us, everyone.
19.
Please, your lordship. Lordship, this is an bail application. The accused has been in custody for 400 to 25 days till today, lordship. Commercial quantity, lordship. May I read out the FIR? It is at page 12. Starting from page 12. 16 is the Izahar.
Page 12.
Page 12. Starting from page 12, let us come to page 16, lordship. This is to inform you. That today at 3 p.m. a specific information was shared by source regarding a peddler is selling huge consistent of ganja to the teenagers at Hatibonda Gaon near boiler farm of Abhijit Datta. Accordingly, a GD entry was made by me, Bhait Solong, PPGD number 91 dated so and so, and the matter was informed to the SDPO, Goliabor, and OC Oloni PS over telephone. I, along with the following PIC staff, get ready to lay operation was carried by GD Nong 92 dated so and so, and carry along weight machine and other essentials. I, along with the following staff, get ready to proceed to Hatibonda Gaon. So, lordship, at around 3 p.m., the SI had arrived at the scene and he conducted the search, lordship. Lordship, in this matter, lordship, I would like to bring your lordship's attention to page number 30, lord. First of all, it is a notice under section 48, lordship.
Yes.
Lordship, the notice has been served to the wife of the accused, but lordship, the wife is not literate in English, lordship. As you can see, the signature, lordship, it is in vernacular. Not a single part of the notice is in vernacular, lordship. And lordship, moreover,
because this will have another component, I think. Because yesterday also I saw. I think it will have a back face. This was arrested in
7-3, lordship. Apprehended on 6.
So probably it will have another sheet. Just check from the record. Have you seen the record? I think it will have another sheet. Just check it. I think it will have, because obviously this is not sufficient, but it will probably have another sheet. Let us check it.
And if your lordship may come to page number 29 as well, lordship. Page 29. There is the inspection memo, lordship, as laid down by the DK Basu guidelines. Lordship, there is nothing to show that he has been taken to the medical practitioner. The signature
In your medical and health officer, Uloni CHC. In many cases, they are doing this. Name and designation of the MO on duty. No injury found. He was examined, medical exam. He was examined. Kindly check that.
Lordship, moreover, he was remanded till 10. There is nothing to show on record that he has been taken to a medical practitioner. He may be subjected to torture as well, lordship.
No, but we have to, prima facie, we have to go by this report, right?
Yes, lordship.
We have to prima facie go by this report. Of course, these things always have to be seen critically.
Yes,
this I would say. They have to be seen
lordship, regarding the section 47 as well. Lordship, though he may know how to write his name in English, Lordship, he is not well conversant with English, Lordship. He is in fact just a 10 first in Bodo medium school, Lordship.
So let's see what the
Lordship,
document says.
moreover, the accused is from BTC, Lordship. We are not well conversant with Assamese as well, Lordship.
Anyway, so
My lord. My lord, yeah.
in a language that he understands, not necessarily official language or non-official language, a language that he understands. That's all. On this matter, on this aspect, perhaps broad substantial compliance might do, and as long as he understands. But nowadays, the best practice is to give it bilingually also.
Lordship, and it has been more than 425 days, Lordship.
Let's see otherwise we have to go into merits. Have you seen the full notice?
What is my lord? The signature is in Hindi.
No, Lordship, that is Devanagari, Lordship.
It was nowhere mentioned, my lord. That my lord. Mentioned, my lord.
Let us see the full notice. So this is the notice does not have the grounds of arrest. It has. Must be mentioned. So this is the first page, I think. There will be another page, I think. 47, 48. This is the first page.
There is no.
Not in detail, man.
Oh, then it will be hit. Just can I check it once? Then it will be hit. If this is the only one, then it will be hit.
Sorry, 46 on page number 20. 47 is on page 26.
Yeah, what the text number and text number are mentioned.
This accountability has to be fixed. This carelessness cannot be.
Moreover, Lordship, I would also like to bring your Lordship's attention to the FIR itself, Izahar itself, Lordship. In page 16. On the bottom, Lordship, may I read it out, Your Lordship?
Page
16.
Bottom is.
Yes, Lordship. In the bottom.
Mhm.
In the meantime, Shyamanta Sharma, APS, SDPO Kaliabar had arrived at the PO and a written authorization was issued to me, was empowered by the government of Assam by notification so and so, disputed 15 May 1995 under section 41(2). Such authorization. The matter was also informed to SP Nogao over telephone and he directed me to take necessary action. But Lordship, it is mentioned later, Lordship, in the FIR. But he said that he went around 3:10 p.m. But Lordship, in the CD, there is no such paper of authorization, Lordship, on record.
But the notice is incomplete. Notice is incomplete. We have to fix accountability. The learning period is over now. You have to follow it now. Heard Mr. So-and-so, Land Council for the petition. Invoking 483, it's okay, no problem. The 483 BNSS, the petitioner is seeking regular bail in connection with Uloni PS case number 15 of 2025 under the NDPS Act, which after completion of investigation was charged sheeted and registered as NDPS case number 164 of 2025, pending before the, it is from Nogao?
Yes, Lordship.
Or Udalgiri?
Nogao, Lordship.
Pending before the learned additional session judge number 3, Nogao. Full stop. The petitioner was arrested on 7/3/2025. Full stop. The learned counsel straight away takes the court to the notice under section 48 and 47, section 48 annexed to the petition, and submits that it does not have details regarding the grounds of arrest apart from being in grounds of arrest, full stop. The case is stated to be presently at the stage of trial. It has started
Yes.
trial.
Trial has started, Lordship, but co-accused has not appeared, Lordship.
The charge not framed.
Charge not framed yet.
Full stop. Reached the stage of trial, though charge not yet framed. The scanned TCR has been received. Full stop. From the scanned TCR, I have perused the notices under section 47 and 48 given to the given at the time of arrest of the petitioner on he was arrested on 7/3/2025. Full stop. 47 notice 2 uthai dibo. Full stop. Ever since the Honorable Supreme Court laid down the law in Pravir Prokasta, followed by Vihan Kumar, it has been reiterated in several decisions of the Supreme Court as well as different high courts, including this court, that all the procedural requirements have to be followed at the time of the arrest. Full stop. The arrest memo should contain signature of the arrestee as well as witnesses in terms of section 36 BNSS. The notices under notice under section 47 BNSS should have grounds of arrest in reasonable detail and specific to the arrested person. Full stop. And written or explained to him in a language that he understands. Full stop. Further, the notice under 48 BNSS also has to have such grounds of arrest and delivered to the family member or nominated person of the arrested person. Full stop. These procedural requirements have been held to be mandatory by the Honorable Supreme Court and several decisions of this court in terms of Article 22 of the Constitution of India. The failure to, it has been held in several decisions that failure to comply with these procedural requirements could constitute a fatal infirmity in the arrest procedure, thereby making the further under trial or pre-trial detention of the accused untenable and requiring him to be released on bail without going into the merits of the other merits of the bail petition, other merits of his case for bail. In serious matters pertaining to drugs, etc., it is even more crucial to comply with these procedural requirements. Procedural requirements, so that if the accused is genuinely required to be detained in custody, such an exercise is not defeated on technical grounds due to infirmities in the arrest procedure. Full stop. The law in this regard has already been crystallized, and therefore, in the present times, in 2025-26, there would be no justification or excuses for not complying with these procedural requirements. Full stop. The law enforcing authorities have also invested in trainings regarding the same. Full stop. Coming back to the facts of this case, in view of the aforesaid nature of the notice under section 47, the same is vitiated and constitutes a fatal procedural infirmity in the arrest of the accused at the time of arrest of the accused. Accordingly, in terms of the governing law, he is required to be granted bail, as his further pre-trial detention is untenable. Accordingly, 75,000 with one surety of the like amount to the satisfaction of the concerned learned court and subject to the condition that he shall not abscond, he shall be available for the trial, and he shall not hamper or tamper with evidence, shall not commit any illegal activities, including any activities prohibited by the NDPS Act, full stop. The bail petition stands disposed of. This is which police station? Which
Uloni,
Uloni is in which district?
Nagaon.
No.
State case, my lord.
No. The jurisdictional police station is Uluwani, Nagaon.
Yes.
A copy of this order shall be sent to the learned Superintendent of Police, Nagaon, for information and the needful, and also for further training of the police personnel, if so advised.
Much obliged, Lordship.
Into 45. এটা কৰি লওঁ দিয়ক পটকে হৈ যাব এইটো আৰু এইটো এটা আছে ফেইল শেষ হৈ যাব তিনিটা কৰি লওঁ
20.
Right, please, Lord.
Yes,
And in this case, my lord, the petitioner number 1, my lord, is 53 days lordship, and 2 is 58 days lordship in judicial custody lordship. Now kindly see, page my lord, 11 is the FIR lordship, and cross affair is also there, my lord, title suit is also there lordship. Now kindly see, first of all, lordship, case 11 lordship. My lord, I am accused, the petition number 1 is the, my lord, accused number 4, and 2 is 6 lordship.
Some land dispute.
The land dispute lordship, the title suit is going on lordship. In that case, we are, my lord, father of the petition number lordship. FIR is at page 11. Lord.
Yes, I've seen.
My lord, the
one person died. Right?
One person died, my lord. He was admitted in, my lord, AIMS lordship. Immediately after taking treatment on that, the same day lordship, he was released. He was okay lordship. He went home lordship. Then, my lord, his health was stated to be deteriorated lordship. My lord, then he in a local civil hospital, he was admitted and declared dead lordship. Now our case is lordship. He expired, my lord, in the subsequent event lordship. Now, my lord, the case diary as well as the, my lord, injury report from the AIMS was, my lord, called for by the last order lordship. Now cross
just a minute. He's the Shah Jahan Ali is accused number 4
lordship.
Right? And Azizur Rahman.
Azizur Rahman is the, my lord, plaintiff's son lordship. 6.
Acha, Azizur.
My lord, Shah Jahan Ali is not related with the, my lord.
Azizur Rahman.
Now, my lord, kindly see the, my lord, my cross FIR lordship. Cross FIR is at first, my lord.
Page.
At page 34 lordship. My lord, this is very important. May I read lordships?
34? Wait.
34 lordship. With due respect, I beg to state that on 5/3/2026 at around 12:03 a.m., the below mentioned accused persons armed with daws, daggers, sticks, sharp weapon objects, etc., collectively entered our land situated at Pokalbhanga, Jagigao, and forcibly attempted to construct a house. When our family saw this and raised objection, he brutally assaulted. It should be their lordship. They brutally assaulted my relatives, namely Sohaid Ali, Alimon Nessa, Ulzan Nessa, and Umesh Kulsum, and me with daws, daggers, and sticks, causing grievous injuries to various parts of our persons. Not stopping there, it should be their lordship. They also damaged our house, causing extensive loss, and looted our household articles. Furthermore, he assaulted my brother-in-law on the head with a sharp weapon, causing severe injuries. All of us being seriously injured have undergone medical treatment at Duke Size Hospital. There was a delay, an explanation of delay lordship. Now kindly see, my lord, the injured at page 33 lordship. My lord, he was, my lord, the Shohid Ali. My lord, the named person in the injured stated in the FIR lordship, page 33, head injury was that he was bedridden lordship. My lord, this is a case lordship. Now kindly see the title suit lordship.
Just a minute. This SIR was lost on 10/3.
My lord,
And the
subsequently.
same
what-
day, same day.
No, yes, lord, it's a incident is same time, lord, 11, I'm sorry, 12, 11, sorry,
It's the same day, same incident.
same,
This
12,
was, this
3
was
a.m.
logged on 7/3.
My lord,
This
same
was-
time, lordship. My lord, this is a case, lordship. Kindly see the title suit, lordship, for a moment, lordship. Title suit at page 25, lordship.
Just a minute.
Page
Dolcom.
25, my lord, Umar Ali is my father of the petitioner number 2. Azizur Rahman's father, lordship. He is the plaintiff, lordship. Now, informant is at my serial number 3. My lord, office-
It is at page
my lord, page 25, lordship.
title suit.
Title suit, lordship. This is very important, my lord. What is the, my lord? Umar Ali is the plaintiff, lordship. He is the father of the accused petition number 2, lordship. Azizur Rahman's father, lordship. Now, Zamir, my lord, he has expired, lordship. This is he defendant number 1. My defendant number 3 is the, my lord, informant, my lord. Other, my lord, 2 is the son of the Zamir Ali, lordship. Zamir Ali, my lord, expired, lordship. Now others are my relatives, lordship. Now, lordship, kindly see page 28.
Yeah. Yes.
My lord, paragraph 9, kindly see, lordship. What was their contention? Their contention was there, my lord, we, my lord, had entered into their land, lordship. Now kindly see paragraph 9 of the title suit, lordship. This is pending before the land civil court, lordship. The cause of action arose on 18/6/2018. Also, the defendants, opposite parties, again tried to dispossess the plaintiff petitioners from the suit land, and thereafter also they are trying to dispossess the plaintiffs petitioners from the suit land and threaten the plaintiffs petitioners to vacate the suit land immediately. Now, my lord, prayer is, my lord, for permanent injunction, lordship, restraining the, my lord, defendants, lordship. Case is, lordship, the cross affair, it is, my lord, stated specifically, my lord, my lord, herein informants, my lord, people came, my lord, and tried to construct house in the, my lord, that suit land, lordship. This is a, why I am submitting, my lord, this is a case, my lord, where this is not a, my lord, murder, my lord, this is a clear case. Even if the CD is against, my lord, their material is their, lordship. My lord, this is a, my lord, not, my lord, intentional killing, lordship. Sudden provocation, my lord, they came to, my lord, petitioner's land, lordship, and there was a quarrel, lordship. This is a, my lord, case, my lord, 105, lordship. In that case, my lord, the maximum punishment is, my lord, 10 years, lordship. It may be extended to 105, my lord, second part, lordship. My lord, even my lord, the deceased, my lord, he expired, my lord, my lord, my lord, due to the injury sustained. Even then, lordship, this is a case of 105, my
That will
lord.
be decided later.
My
Anyway.
PNSS, lordship. So already, my lord, they have been, my lord, interrogated, lordship, 58 days in judicial custody, my lord. One is 53 days, lordship. So in such a condition, circumstances, my lord, their further custodial interrogation may not be necessary, lordship.
Anyway. Okay.
Injury
So,
report from AIMS was
that is all. That is also received. AIMS. Not received. Can we dispose it of or?
That may be called for, my lord.
My lord, already, my lord, 58 days, lordship. My lord, if it
Anyway,
is in the, my lord, it is a, my lord, case under section 105 part 2, lordship. It is extended to 10 years.
At the moment, we have to go by this the penal provisions. Unless there's something, whether it is culpable homicide, not that's it will be premature to determine that.
Eyewitness of my lord. Clearly indicated, my lord.
Okay.
My lord. So, due to, my lord, for my,
Achha.
apart from this, my lord, he sustained other injuries also, my lord. Now, then, my lord, forearm, shoulder, right leg, then my leg, and my lord, part of the body, my lord, shows, my lord, that He was assaulted by.
In this regard, what I am submitting, Lordship, even then, Lordship, this is a case of sudden provocation, Lordship. My Lord, the dispute is there, quarrel was there, I also admit, Lordship. My Lord, the petitioner number 2, my Lord, went to save the other, my Lord, victims, Lordship, family members.
Okay, wait, I've heard you. This much, this much from you for the informant. First tell me, should we, will the Ames report be necessary? Then in that case, I'll hear you, but still I'll keep it pending then.
Their contention is that, my lord.
He died later.
He was taken to AIMS, my lord. Then he was
not there.
put away, my lord.
He died.
Again, my lord.
Uh,
Then ultimately he died. My lord.
he died. So if you say that it can be disposed of, I'll dispose it of.
Yes, my lord. My lord, postmortem. Sir, eyewitnesses is implicated. I'm not denying the statement of the complainant. Eyewitnesses, my lord.
Can you flag it? Yes.
Length of detention may be considered whether their further custodial detention is, my Lord, necessary, my Lord, in such a circumstances, my Lord.
I'll see.
Such a case.
Let me hear him. Come, this way.
And from there, the top. This is to be. Title should not. Title should as per their submission. But that was not part. One can, if there is no merit. Ask in favor of the. In this year. Still, had. And basically, they will not be. And another thing, okay. Come to the delays of the. So then.
The villages are different.
Petitioner.
My Lord, what I am submitting, Lord.
Mr. Borua, because whatever it is for satisfaction of both sides, especially the petitioner counsel, I think since suppose it gets rejected, then he may be agreed because let's get the Ames report. Can you get it? We'll take it up next week early. Quickly, we'll take it up on Wednesday or Thursday latest. That will be best. Keep it pending. But I'll record a little bit of submission. Mr. Ahmed, learned counsel for the system, and RJ Borua. And your good name, please? R. Islam, learned counsel for the informant. Full stop. The Mr. Ahmed, learned counsel submits that with regard to the incident, there was a cross FIR resulting in the registration of Dalgaon PS case number 47 of 2026. And full stop. And one of the persons from the side of the accused have also sustained serious injuries on his head, and a photograph, a copy of the photograph has been also annexed. Full stop. The present case in which bail is being sought for is Dalgaon PS case number 41 of 26, registered on the basis of an FIR dated 7/3/2026 regarding assault, regarding trespass and assault into the land of the informant by the accused persons, 14 in number named in the FIR, and causing assault and injuries, as a result of which his father, the informant's father, Jamir Ali, expired. This Mr. Amit, learned counsel submits that there is a background of land dispute between the parties over which a title suit is also pending, and that and he further submits that considering the length of detention, the petitioners, the granting of bail to the petitioners may not prejudice the investigation, further investigation. On the other hand, the learned additional PP, Mr. Borwa, on the basis of the case diary, submits that the statements of eyewitnesses have directly implicated the petitioner as being involved in the assault, and that the victim suffered numerous injuries on his body. Mr. Islam, learned counsel for the informant, objecting to the grant of bail at this stage, submits that it is a case of planned murder, and that the accused persons came to the village of the informant site, which is another village, at around 12:30 a.m. and committed the incident. Objecting to the bail, the learned counsel submits that granting of bail at this stage may lead to hampering of evidence. On the prayer of the learned counsel for the petitioner, a report from AIMS Gauhati, where the deceased victim was taken initially, was called for, but it has not been received. The prosecution shall procure the said report. Okay, Mr. Bora, can you?
My lord, I have another prayer, lordship.
Yes.
My lord, as there should be common witnesses, lordship, and the injury is there from the other side, lordship. My lord, CD in other cases may also be called for. My lord.
Should I?
Yes,
he seeks the other case diary also.
Dolgao PS
Same incident.
Yes, Lord.
Same incident.
Yes, Lord.
But it was registered. No, but it was registered on 10th. Is it the same incident? Then we can call. Yeah. Over the same incident or different incident?
Same incident, lordship. FIR is same, lordship. Same time.
We can call.
That may be called for. In other case, it was called for, lordship.
Then sometime. Further, on the prayer of the learned counsel for the petitioner, the case diary of the purported case, cost case, that is Dolgao PS case number 47 of 2026 shall also be called for. Repeat code. Okay, this case diary you can retain. The case diary of Dolgao PS case number 41, which has been received, shall be retained. Okay. So you can suggest a date, please.
Already in a case, lordship, in other case, lordship, or
Let it be on
in anticipated bail.
Can it be on 19 Tuesday? 19 or 21? 20.
22. Or like that.
Okay. A copy of the order shall be furnished to the learned additional people.
Or like that.
Regular bail application also while in custody for more than 1 year, 3 months, 70 days, more than also. Also kindly page 61 is a seizure this way.
Are you on technical grounds or merits? Grounds technical.
Yes, that is on page 66, lordship. Page
61, yeah. You told me to come to 61, so I'm on 61 first.
Yes, lordship, then 61.
Search come seizure list.
Yes, search cover. There's a search come seizure list, that's name and address. This is Surjit Singh. Seizure is from Surjit Singh. That's it. I am Rup Singh. Seizure was made on 3/8/2024. Accordingly, he was arrested on that day, lordship. I was arrested on 17/1/2025. Now, lordship.
Rup Singh.
Yeah, Rup Singh. This is
now I remember.
Page 66 is a certified copy, lordship. Photo certified copy. This is a notice under section 47 BNSS.
This will not do if this is the only notice.
It is not complied with, lordship. Regarding 48.
So sometimes there is another component. narrating details, you know, on the backside.
48 is not provided, Lordship.
Anyway. Surjit Singh. Yes, yes.
Not figure. 47.
Memo bias. All they have to do is copy paste actually. This is reasonably detailed, but these are technical things and they should take care, you know. Yes, yes. And who else if not NCB? NCB is the leader. It is the NCB is our Indian equivalent of the DEA of USA, Drug Enforcement Agency, you know, or big drug, you know, these things. Anyway, it is all never late to learn, but time is running out. You know, serious matters. Also, sometimes you have to be the authorities, you know, because I earlier when I passed an order to the SP, not that I want some DP to be taken. No, I'm not like that. But at least if I keep making a mistake, that should be pointed out to me. It will be changed. Little bit of care, you know, because you know people should get liberty. But thing is that if then we are unable to see the merits also, if it is on technical grounds, whether it was justified, whether you know 37 is applicable. Anyway. So that actually, I think probably if I've not understood wrongly, that we have not reached that stage. Maybe someday the law may say that if it's substantial compliance, this will do in serious cases. But today, as of today, I think probably it is not. But these things we should take care because drugs is a special menace, right? Everyone's children are at risk. Everyone's children. Anyone who has teenagers or all. I mean, of course, learned counsels are doing their professional duty and they have to do it well, no doubt about that. So, but it's a collective this thing. And main thing, trial should be expedited. Main thing is that trial should be expedited. Heard Mr. Thopia and learned it, Deputy as the RKD Chowdhury. Please have a seat. Invoking 483 BNSS, the petitioner is seeking. He's on bail, the other one. He's got bail.
No.
He's not jail.
He's in custody.
But Surjit Singh.
His person is recovered.
Okay, but in his case, the notice was furnished. In his case, the petitioner is seeking regular bail, NDPS 1 of 25, within bracket, arising NCB crime 08 of 2024, pending before learned additional session judge Ronia. The gist of the prosecution case is about recovery of commercial quantity of contraband in the nature of ganza from the accused persons. It was recovered from him, not from him,
not
from co-accused Surjit Singh. And how was he implicated? He was also in that truck.
No. In fact, has come to light that
Okay.
petitioner,
As a conduit. And the present petitioner was arrested based on the revelation from the co-accused. The learned counsel. Okay. The learned counsel has taken the course to the notice on the 47 and submits that the same does not contain the grounds of arrest in the manner and the manner required, full stop. The scan record has been received. The learned Mr. Chaudhary, the learned Deputy SGI, fairly submit that though he could not find the notice under 48 in the record, but the notice under 47 has been found. And though it tallies with the full stop, has been found. It is submitted that the grounds of arrest in reasonable detail have been mentioned in the memorandum of arrest. It is available in the record. I have perused the memo of arrest, comma, and the notice under 47 BNSS. Full stop. The said notice may be reproduced herein below. Short ke likhite. Full stop. In terms of the governing law on the subject matter, vis-a-vis Article 22(1) of the Constitution of India, within bracket, Pravir Prakasta Vihan Kumar likhite pa, so and so. The full stop. The aforesaid nature of the notice would not meet the requisite standards, requisite constitutional standards in terms of the settled law. Settled law. Full stop. Consequently, the further pre-trial detention of the accused is untenable and is required to be granted bail on the aforesaid technical grounds. Accordingly, such view of the matter, 75,000 with one severity to the satisfaction of the concerned learned court, and subject to the conditions, regular standard conditions. Bail petition stands disposed of.
Is 47.
May it please also. But this is a regular bail application, madam. The FIR is at page number 14. But as per the FIR, my lord, the allegation is that, my lord, while the petitioner was traveling in a train, my lord, 26 kg of ganja was allegedly recovered from the bag of the petitioner. Now, my lord, the FIR was registered under 20B2C, and since 17/12/2025, my lord, he is in jail. 17/12/2025.
Okay.
My lord,
There was some technical issue here also, right?
Yes.
Grounds of arrest.
Regarding, my lord,
47 is okay.
48.
47 is okay.
48, my lord, what
much will do.
WT message is there. But whether, my lord, the WT message was received, because, my lord, my instruction is that, my lord, his family members never received the WT message, man.
The investigating agency always has to, because see that these things can have also some vested interest, to defeat this notice. Suppose in certain cases, that the family members may also avoid receiving, but so they have to, that's okay. I mean, can't help it. So the investigating agency has to also take suitable steps that suppose it is sent by WT to the concerned police station. The concerned police station goes and delivers, like postal. If it is refused, he has to write refuse. It was conveyed, but it was refused. Nobody took it. That's it. Anyway, so I remember now we were supposed to check the 48 notice, that aspect. 47 is okay. It's okay. 47 is okay. This much will do. You cannot be hyper technical also. But 48, you have to guide the court. But he says that according to his instruction, it was probably never received.
Never received. That's why, my lord, no bail prayer could be moved on the first day of remand, my lord.
You cannot assume also that it was not delivered. That is also there, looking at it from another side. Anything in any material to what happened regarding that, apart from the WT? We cannot, because they should make an endorsement in the diary at least. They should, please have a look. Because they should have a, otherwise kindly, because a commercial quantity, then kindly take an instruction regarding this. Because both sides are true also. Actually, we cannot assume that it was delivered. We cannot assume that it was not delivered, actually.
Here is also another additional ground, my lord, regarding non-compliance of section 50 also, my lord.
50.
50.
50 is 47.
No, 50 of the NDPS, my lord.
Or
Since,
50.
my lord, yes. Since, yes. My lord, normally the thing is this, that
For trial, 50 is absolute mandatory.
yes.
42 is, there may be some issue,
Lordship,
potential
kindly-
compliance.
kindly-
But 50, Baldev Singh holds the field, 1999 Supreme Court, from
Kindly-
body search. If
No,
it's,
my lord, there is a recent judgment also, 2026 judgment, my lord, which says that, my lord, if the search is same, person and the body, then 50 will have to be complied with. Recent judgment, my lord.
person and body.
Yes, in the same search, my lord.
Yeah, no, if the contraband is recovered from the body.
No, if it is recovered from the bag, but the search is same. In the same search, my lord, a person and the body.
But the settled principle is that if it is from a bag carried on the soldier, then
Lordship,
50 is not there. Something from the body, from your pocket, suppose, from your shirt pocket, pen pocket, from a salwar pocket, something of that sort, as
Yes.
far as I know. Huh? But this is very strict,
Yes.
strict compliance.
But there are two.
I like to see that judgment.
I'll
The law
please-
is all, it's 99 is long back,
Yes.
26 years back.
Yes,
Constitution bench.
Baldev Singh said that, my lord, if it is only regarding the bag, then 50 has to be complied. 50 need not be complied with. Only regard to the person.
If it is also from the body,
But
then definitely.
if the search is same, from
Then
the same
it's-
search, my lord, the person and the body are searched, my lord, then 50 will have to be complied with.
Well, that is also there, but
Yes.
suppose there are two parts of the recovery. Suppose one part is from body, one part is from bag. Suppose carrying bag, big carrying bag. Suppose then, and 50 is not complied, then that part of the recovery will fail, but that may not fail. The bag part may not fail. Right.
And let them have the case there, my lord. Then I'll submit on both the grounds, my lord, regarding 40.
They're better to have the case there.
But, my lord,
Remaining parts of the case there, especially, and you take instructions regarding the service, the delivery. They should have. Full stop. I heard Mr. S. Das and MP Goswami, Learned Counsel. The Learned Counsel submits that as far as instruction, though a wireless communication was purportedly made regarding the notice under 48 BNSS, but but it was never delivered to the family member. Full stop. From the scan record, I find that I find the said wireless communication. Full stop. Since non-compliance with section 48 is one of the contentions, one of the grounds on which the petitioner is seeking bail in terms of the governing law. Therefore, the prosecution shall procure the remaining parts of the case diary, the full case diary, registry. Okay. The registry shall procure from the learned trial court the full component scan copy of the full case diary. Full stop. Further, the prosecution, you will take instructions. Further, the prosecution shall take instructions from the concerned IO regarding the compliance with the notice under 48 BNSS and about delivery to the concerned family. List on
18 or 19? 18.
19. Let it be on 19.
19. I'll
give you a quiz for the weekend. Tell me if the recovery is from money bag in my pocket,
my understanding
will
is
50 be necessary?
yes. Lordship may go through this judgment, my lord, in the basis.
It is a bag, but it is a money bag. So you already have the answer before. Hold on.
45 time being.
I'll see. Just
Yes.
a minute. Will not waste time. Because I am also seeking an answer to this question.
Last paragraph.
This was for money back.
Para number 20.
Let's see this. Let's see. Okay.
Section 50 will have no application, but if the bag carried by him is searched and his person is also searched, section 50 would be applied.
Look. No, don't it.
Highly obliged.
Time being 45.
Sorry, Madam, I was in another court.
No.
Madam, this is a case, your lordship will find, I do not find anything for further custody, my lord. Your lordship kindly say page 17 in the FIR. The prohibition order was there, madam, from the DC, not to fish.
Not to?
Not to fish. Thereafter, my lord, actually, that they have violated as per FIR.
Not to also fish.
Yes.
What offense is made out? Theft.
Madam, there, no, theft is not there, not at all. Even the FIR does not say. Only I find 223, if at all, if it is correct.
220.
Disobedience, it is available. Section 223, madam. Violation of 163, madam, 144. That is the violation, madam. As per FIR. If we assume that it is correct, then it will come under that, madam. 223. And now today is 12 days, and your lordship kindly see what the IO, you will kindly see page 20, madam. In the forwarding about, actually 35 notice was given to me. We appeared. Thereafter, my lord, 35, 3, you will kindly see page 20. Handwritten, my lord. Your lordship will find why I have not released the accused persons. Release means we appeared. They ought to have been released, my lord, 35, 3. They say the accused persons were not released on the notice under section so and so, as if the accused persons were released on notice so and so, the local people may cause harm to the accused persons.
That has come.
No, it is a motion, my lord. Whether it is further custody is required or not, I am only on that, my on the face of this, my where is the remand? Remand, my lord. And we have, my lord, your lordship, kindly see order is there. We have been authorized to, my lord, go for fishing, my lord. Page 26, your lordship will find. Initially, order was given to the society. Then society has authorized us. Your lordship, page 26.
The fishery was settled.
It was settled with the society.
Society. And society gave the
authorized page 26.
Authorized the society gave the authorization to the petitioner.
Your lordship, 30%, 6, your column 6, your lordship will see. Page 26.
Column 6.
Yes. Logot taka mane honke mane initially 2 persons, along with them 30%. We are one of my lord, 3 of them, my lord. Where is the criminal, my lord? That is what I am saying, my lord. Authorized. Where is the theft also? Theft also does not come. Settlement order is page 24. Settlement order. Settlement given to society.
24.
Yes, page 24. In terms of this matter, page 26 come.
Read petition order.
Yes.
Person.
Government has given for 7 years. Yes.
Rules.
And 12 days matter arrested on 21/4/26.
We'll get the case diary, but I think it can suspend it for some time. Heard senior counsel and so on. KK Parasol. For the petitioner is seeking bail in connection with Viswanath Sareli PS case number 84 of 2026. And that's an FIR was lodged. FIR dated 21/4/26 was lodged by ASI Binod Pegu of Biswanath PS, Biswanath Sarli PS, with the allegation that in terms of the order promulgated by the District Magistrate DM Biswanath on 30 March 2026, fishing was prohibited in certain natural bodies. The gist of the allegations is that the FIR named accused persons, despite the same, conducted fishing illegally. They were arrested on 21/4/2026. Drawing attention to the relevant annex documents, it is submitted that on 6/12/2029, the DC Biswanath had settled the concerned fishery in favor of the society, and a copy of the same is also annexed. The society in turn permitted 30 persons to conduct the cooperative society
with
authorized 30 persons, including the petitioners, to conduct the fishing. Full stop. In the meantime, this promulgation came.
Promulgation came.
While the promulgation, because it was already settled.
Yes, already settled.
Why the promulgation came? That is a subject matter of separate subject matter. That may be an administrative matter, but anyway, full stop.
Theft is not there at all. This is all the non-binding section.
Call for the case diary, but in the circumstances, I'm of the considered view that the pretrial detention, the ongoing pretrial detention of the petitioners can be put on hold. So accordingly, in the interim, they are allowed to go on bail of rupees. How many petitioners? Three. 30,000 each, the surety of the like amount each, for the satisfaction of the concerned
CGM Biswanath.
CGM Biswanath. And subject to the following conditions, they shall cooperate with the investigation and cooperate with the process of law, and not commit any illegal activities. List on, you can give a longish date, last week of May. 3rd of June.
Obliged to us.
No problem.
Hearing 24. 24.
Last day also, nobody appeared. Some miscommunication, but the interim order is there. CD is there. Not received. None appears on call, full stop. The case diary is also not received. The petitioner was granted an interim order on 5/2/2026. The same shall continue till the next date of listing. But we fix it next week. 14. Let it be 14. It's coming to me. Named in the FIR has already been released on bail. Full stop. The same is not disputed by the prosecution, which has also received the case diary. Full stop. The present petitioner is not named in the FIR and is stated to be the brother-in-law of the main accused.
Brother-in-law of the victim. Brother-in-law of the victim. Brother-in-law of the victim.
Brother-in-law of the victim. Brother-in-law of the victim. It is submitted by the learned additional PP that that the investigation has not found implications against the present petition. Learned amicus also fairly submits that though there are allegations of the POCSO Act, but it appears to be directed more against the FIR named accused. That necessary orders may be passed as follows. First, in view of the lack of implication against the present petition, it deserves to be granted bail according directed that 20,000 with one cigarette. Satisfaction of the arresting authority, subject to the condition that we cooperate with the investigation.
Anticipatory bail, Your Lordship.
Huh?
Anticipatory bail.
Yes, yes, to the satisfaction of the arresting authority. We will cooperate with the investigation, return the scene.
Highly obliged.
Other matters, please take time. I think second half will be possible, no? I have to go. Kindly take the dates. No? Hearing will adjourn. Admission matters are only left. You kindly take the dates.
My lord, 3 and 43 be taken together, my lord, maybe fixed
on the next
by
day.
First, second week of June, my lord. Together, my lord.
Item 3 and 44 take together and in the second week of June on a date to be fixed by registry. We'll give you the dates on this. Okay.
Item 2, this admission matter, part heard matter.
Mm.
And if it is possible, next week, Lordship.
Next week or thereafter. Next week.
Yeah, 24.
Next many matters actually. Let's
20 of May.
20th May, Lordship.
28.
20, Lordship.
20.
We fixed many matters actually on that day. But this is part third, it's also true. Let us try on 26 maybe. Part third will give priority. Okay, you take the dates. Interim will be extended, no problem. Okay.
Hey, lovely. 26 to Idor Agdina Porisar.